everyone. I just want to welcome. Hello. Thank you all for joining. I'm delighted to moderate this panel. If we had it took some time for it actually to upload my video and audio. So apologies for just a couple minutes of delay. With the Zoom world we live in. And so I'm just going to go ahead and get started because I know we have limited time. Good afternoon. My name is Rachel Ricochet. I'm a professor at Temple University Beasley School of Law. I'm a faculty fellow with Temple Center for Public Health Law Research, and I am delighted to moderate this panel on critical approaches to law enforcement and intimate partner violence. We have the nation's experts on this topic, and the panelists today in their discussion of unintended consequences of punitive interventions, I think it joins such a timely and important conversation about alternatives to incarceration and police involvement, some of which are grounded in public health. And I'm really thrilled to be here. So without further ado, I'm going to introduce each speaker as right before they present. And our first speaker is Aya Gruber, who is a professor of law at the University of Colorado School of Law. Professor Gruber has published numerous articles in leading law reviews, and her recent book, The Feminist War on Crime, The Unexpected Role of Women's Liberation in Mass Incarceration, published just last year. A phenomenal read. In fact, I'm going to put the link. It's one of the impetuses for this conversation. And I know she's going to talk a little bit about it, but there it is. Get it while it's hot. And Professor Gruber, over to you. You're muted.
Of course. You need to start every Zoom conversation with "you're muted." And somehow I also managed to not mute myself at inopportune times too. So I've got that down. I've got that aspect of Zoom like that. Thank you so much, Professor Ricochet. I am delighted to be here with just friends and people whose work I so admire, and to learn and hear from the experts in this field. And thank you all for being here. I know that this is a really stressful time, and there are so many demands on your time, and making some time to listen to me speak for a minute, I really appreciate it. So I just want to talk about my perspective coming into this conversation, because I have a very specific perspective. And my perspective is that of sort of a diehard feminist and former public defender, and grappling with, what was a very maybe prototypical feminist desire to see batterers held accountable, right, through the criminal justice system. And then having the experience of practicing within a domestic violence court as a defender, and seeing that the model of, mandatory arrests, no drop policies, jail time, etc., was really complicated, not just for defendants who obviously suffered carceral consequences, but also for victims and for families who, didn't necessarily want to separate, who faced deportation. Maybe the women faced their own risks within the carceral system. And so that kind of started me looking into, well, exactly how did we get to this state of there being these pro-arrest and mandatory arrest policies as the first order response to domestic violence, and what role did feminists play in it? So I really looked at this from the perspective of a feminist and a defense attorney in internal conflict. And in writing this book, which is kind of the resolution of these dilemmas for me, and it actually covers law reform from the 19th century to today in different areas, not just domestic violence. But in researching this book, I really wanted to go back and look at sort of the roots of the pro-arrest movement and how it related to feminism. So that's the story I'm going to tell. And I know Lee and Carrie, Carrie has a policy maker perspective. Lee has a victims advocates perspective, and we've got public health perspectives here. So that's my perspective, kind of the historical feminism meets criminal law perspective. Okay, so today, domestic violence criminalization, as in arrest, prosecution, and convictions, is widely considered a signature achievement of second wave feminism. But when you go back in history, the original battered women's movement of the early 70s was in fact deeply anti-authoritarian. It grew out of 1960s Vietnam War protest radicalism. And so shelter feminists within the movement advocated for nothing less than alternative egalitarian societies freed from the government's dirty hands. Anti-poverty feminists saw battering as a product of a cruel welfare system that drove single mothers to abusers. Anti-patriarchy feminists traced abuse to sexist marriage norms and economic inequality. The varied feminist proposals had really nothing to do with criminal law. They included welfare reform, family law changes, and economic reforms, including things like housewife wages. And researchers outside of feminism traced abuse to social stressors like discrimination and economic precarity, and also rejected criminalization. In fact, in the early days, hardly any experts looked to criminal law, and many feminists were extremely wary of criminal law. So how was it that by the early 80s, law enforcement was at the center of battered women's activism? Well, a particularly influential group of lawyers and victims advocates conceptualized battering as a matter of individual violent men enabled by weak law enforcement. So in my book, I call them legal feminists. We might also say enforcement feminists. In 1976, these feminists in New York filed the landmark class action suit, Bruno versus Codd, and they framed the failure to arrest for abuse as an equal protection violation, right? As discrimination against women. At the time, the New York Police Department allowed police to exercise discretion to mediate the couple to a solution short of arrest. But the suit resulted in a new departmental policy. Arrest is the default response to domestic violence and the mandatory response to certain crimes. So enforcement feminists drew on their experiences with clients who told them horror stories about brutal beatings and officer indifference. And these were real clients facing real horror. However, they were also a specific subset of battered women. The clients had already resolved to separate, and they pleaded for state intervention. But such was not necessarily true of the entire class of battered women the Bruno lawyers purported to represent. And at the time of the litigation, what little research existed indicated that mediation and other non-arrest techniques would more effectively reduce domestic violence. But feminists did not focus on whether arrest worked because they entertained a narrative that established non-arrest as sexist by definition. In this narrative, cops failed to arrest because cops are sexist who believe that abuse is no big deal, or worse, sided with the abuser. With non-arrest defined as an exercise of sexism, every arrest became an instance of gender justice, regardless of the consequence, right? This was feminists' tale of arrest, but there was another tale, the officer's tale. It's true that officers detested taking domestic violence call and often did not arrest, but it was not because they were all communing with abusers. Now, I don't doubt that some officers had an abundance of empathy for batterers, and probably some still do today. But officer testimony collected by the Commission on Civil Rights in the 70s tells a different story. Officers said that they did not arrest because they feared an arrest would escalate the violence or financially harm women. And the most common reason for not arresting was that the victim didn't want it. Officers also testified that they didn't like to arrest because normally when they made an arrest, they felt like they were helping the situation and they could be seen as a good guy. But in domestic violence arrests, sometimes when they made arrests, it was the victim themselves who was berating the police. right? And also domestic violence calls were really dangerous and seemed to escalate on arrest. So this was police officers' story. But within short order, police welcomed the mandatory arrest policies, which they saw as, quote, getting them out of the social work business, as one criminologist remarked. In later years, the police's aversion to touchy-feely mediation became a justification for mandatory arrest. In 1997, Virginia adopted mandatory arrest, stating, quote, by placing the burden on the police to decide whether to make the arrest in a domestic violence case, the law asks the officer to serve as a counselor. It is unfair to the police officer for him to be required to do more than prevent crime. So enforcement feminists clung to the arrest as best faith, despite a growing body of social science that arrest could exacerbate the domestic violence problem. Initially, activists were emboldened by sociologist Lawrence Sherman's famous 1984 Minneapolis DV experiment. That study randomly assigned police to arrest, warn, or temporarily relocate suspects and found arrest most deterrent in a 6-month period. However, while feminists and media were lauding the Minneapolis study, larger scale replication studies were already undermining the pro-arrest finding. By 1992, Sherman possessed enough data to proclaim, quote, mandatory arrest may make as much sense as fighting fire with gasoline. But feminists doubled down on criminal law. For example, in the face of studies showing that arrest does not deter, Lisa Frisch of the New York Coalition Against Domestic Violence wrote off deterrence, stating, quote, our entire justice system fails to deter the majority of socially marginal criminals. Other studies showed that reforms increased arrests of men, but also multiplied arrests of women. And it turns out that feminist sexist cocktail had also overlooked that police often use their discretion not to arrest women. Still, other studies showed that arrest policies produced a stark disparate racial impact. Sherman's 1989 Milwaukee study found that arresting unemployed Black men for domestic abuse made them more likely to recidivate. Joan Zorza, a prominent domestic violence activist and scholar, argued that the study proved that police simply weren't tough enough. Calling the unemployed Black men, quote, society's failures, Zorza opined that arrests didn't work on Black men because, quote, in subcultures of ghettoized people, where imprisonment is common, a few hours in jail may be seen as only a minor irritation or even a rite of passage. So with feminists and police aligned, the pro-arrest program expanded, and today the majority of states have pro-mandatory arrest policies, and domestic violence arrests outpace non-domestic assault arrests. Since the 90s, arrests of women for assault increased by 30%, which sociologists attribute to police not distinguishing between violence that does and doesn't merit arrest. So this is what I argue is the state as a state of affairs that needs to be fixed and changed. And still, many, if not most, feminists and activists imagine that this state of affairs is better than the bad old days when sexist cops had discretion. Okay, so I think I'll stop there because I've already gone over time. And that's a little bit of the history from my book. And thank you very much.
Thank you. Thank you very much. So next is Lee Goodmark, who is the Marjorie Cook Professor of Law and Director of the Gender Violence Clinic at the University of Maryland Carey School of Law. Professor Goodmark is the author of Decriminalizing Domestic Violence, a Balanced Policy Approach to Intimate Partner Violence, and also A Troubled Marriage, Domestic Violence, and the Legal System. Professor Goodmark.
Thank you so much, and thank you for inviting me to be here. I'm going to pick up where Professor Gruber left off, which is to argue to you that criminalization is not doing the work that we hoped it would do. And as Professor Gruber mentioned, I come at this from a different perspective than she does. I have represented victims of violence in the civil court system largely for the last 25 years. And so my perspective on criminalization is very much a product of having been in courts with clients during that time and watched how the system worked, or more often didn't work, for them. And so where Professor Gruber comes from a public defender perspective, I very much come from a victim side perspective. And the reason that I care about the failures of criminalization to do the things that the feminists that Professor Gruber described hoped it would do is because I believe that we are selling victims a false sense of security by suggesting to them that criminalization is going to be the thing that helps them, and that we are failing the victims that we purport to serve by telling them that criminalization will stop the violence against them. So if you look at the rates of violence over the last 25 or so years, what you see is, as President Biden frequently says, intimate partner violence has dropped by approximately 67% since 1994. And while that's true, it's not the whole story. In fact, all violent crime in the United States has dropped 67% since the inception of the Violence Against Women Act in 1994. The difference, of course, is that through the Violence Against Women Act, we have been putting billions of dollars into the law enforcement response to this one subset of crimes, not into all violent crime, and seeing no greater a return in the subset of crimes that we care about in this conversation than we're seeing overall. So problematic if you define working as lowering rates of violence. Then, as Professor Gruber mentioned, there's also not strong social science data to suggest that criminalization is deterring intimate partner violence. Much like everything else in the criminal legal system, deterrence is pretty hotly contested. And I don't have time to get into the research in depth, but I would suggest to you that there is no good evidence that arrest is deterring violence, that prosecution alone is deterring violence, or that incarceration is deterring violence. What there is evidence on is the unintended consequences to the population that these laws were specifically meant to benefit, and that's victims of violence. Fear of arrest currently is preventing people from calling police in the first instance. The National Domestic Violence Hotline did a study where they found that 24% of the victims who had called police were either arrested or threatened with arrest at the time that they called for assistance. Connie Burke, who's the executive director of the Northwest Network, a service provider for LGBTQIA individuals in Seattle, reports that about 50% of their LGBT clients were arrested when they called police for assistance. And that knowledge, that arrest of the victim can very much be an outcome of calling the police, stays with people. So in the National Domestic Violence Hotline survey, 28% of those who had called the police on a past occasion said that they would not do so again because they feared being arrested, threatened with arrest, or physically abused. 17% who said that they had not called the first time said that they, of course, would not call again for the same reasons. And so there's a significant amount of fear out there on the part of victims that interacting with law enforcement will lead to arrest. That's not unwarranted. As Professor Gruber noted, following the inception of mandatory arrest policies in a number of jurisdictions in the United States, arrests of women went through the roof. And that was not because women all of a sudden had become more violent. It was about the ways that these policies were being administered by law enforcement. And disproportionately, that burden was falling on Black women. Arrests of both women alone and dual arrests of both parties became much more common. And in one study of a hotline in New York, found that 60% of the victims 60% of those dually arrested had a previous victimization history with the person that they were arrested with. Had police only talked to them about that, they would have found out. So in response to that, many jurisdictions have passed what are called primary aggressor laws that require police to do exactly that work and to try to determine who the primary aggressor, who the moving party in the violence is. And those laws have had some impact, but they very much depend on who's administering them and how. In addition to the concerns about arrest and threats of arrest, people are concerned that they will be harmed if they call police. That, again, is not an unwarranted fear. There are stories from all over the country about victims who attempted to call police, particularly victims of color and particularly LGBTQIA folks, and were abused or verbally abused or otherwise harmed by that interaction with the police officer who was supposed to be there to assist them. Now, one could argue that arrest is really pretty minimal as kind of bad outcomes go for victims, assuming that, say, there's an arrest but no conviction, that's really not something that we should care about. But in fact, the impact of arrest on a victim is substantial. It creates a public record that someone has been, at least that the police have had probable cause to bring someone in. That public record is discoverable by employers, by licensure bodies, in custody cases, and in a variety of other settings that can be really detrimental to the victim of violence. Suspension of licenses is common. The inability to access services through domestic violence services providers once someone has been tagged as an aggressor as a result of arrest. All of those things are consequences of arrest. And more importantly, I think in some ways, it undercuts it discounts how much trauma is caused by the experience of arrest, particularly for someone who has been victimized. To have not only to have your story not be believed, but to be locked up away from your partners, away from your children, away from everyone you care about, to face having to pay bond to get out, to have to go into a court and in the pose of the offender, even though you have been the victim of a relationship, and then all of the things that we know about the experience of jail in terms of being locked up, poor medical care, isolation, impact on mental health. I don't have time to tell you all of the reasons why arrest for victims is such a horrible experience, but trust me that it is. And so, because criminalization has had these unintended consequences of bringing more victims into the criminal legal system, we really have to stop and ask, is the benefit that it's doing worth the harm that it's inflicting? My argument has been no. I would just note one more collateral consequence that we don't really have time to talk about, which is involvement by the child welfare system. That when victims are targeted through the criminal legal system, oftentimes, even if the arrests, if charges are dropped or things go no further, their children may be removed as a result of their interaction with the child welfare system, another factor that keeps people from engaging law enforcement in the first place. And if that arrest is not dropped, then you are prosecuting victims. And victims are much more likely than other people to take a plea because they want to get home to their children, because they fear the consequences of being found guilty for lots of reasons. Women, particularly women victims, are much more likely to plead guilty even when they have viable defenses. And so this idea that kind of the process of prosecution will sort out the good cases from the bad, given that 95% of cases end in plea bargains, is really not supported at all. In addition, as Professor Gruber noted, in jurisdictions that have no drop prosecution, you may see victims being arrested and forced to testify. Victims are held in the same jails as the people who hurt them are held in, often for days, weeks, or in some cases months. And so all of these consequences are reasons why we need to think beyond the criminal legal system in addressing intimate partner violence. I think that I'll stop there because I think that's just about my 10 minutes. And I thank you so much for allowing us to share these thoughts with you.
Thank you. Thank you. So next we have Carrie Bettner Lopez, who is a professor of law and director of the Human Rights Clinic at the University of Miami School of Law. She was lead counsel on the Gonzalez versus United States, the first international human rights case brought by a domestic violence victim against the United States. Her work has appeared in numerous journals, law reviews, popular media. I'm delighted to introduce her.
Thank you, Rachel. And it's wonderful to be a part of this conversation. I look forward to the discussion as well. I always love engaging in multidisciplinary spaces. So I come from the perspective of a human rights lawyer who has worked in the area of gender-based violence for many years, both previously when I was with the ACLU Women's Rights Project, and then over the past 15 or so years, mostly in the arena of international human rights litigation and advocacy, largely with a focus on human rights in the United States, the idea that we need to bring human rights home, make sure we're applying the same principles to ourselves in the US that we do, that we oftentimes wag the finger at the rest of the world and say they should be doing better. But I had the opportunity, as I mentioned, to kind of take a detour from that for 2 years when I served in the Obama-Biden White House as the White House advisor on violence against women to then Vice President Joe Biden. And that was a huge eye opener for me in terms of thinking about kind of, directed advocacy and practical advocacy, and ways in which I, as a human rights lawyer and advocate and women's rights lawyer and advocate, could think both practically as well as aspirationally about my work. And so I've really enjoyed engaging in these conversations with Aya and Lee specifically over several years, and with many other advocates, lawyers and non-lawyers alike, that span across many spaces. And this is a very vigorous conversation in our country and in our world right now. I think it's really important for us to all take this moment, given the context that we're in, with what many say is a double or triple pandemic, with increased rates of domestic violence that are being documented worldwide, Black Lives Matter and social justice movements that have risen to prominence in new ways and with new audiences, and of course the COVID pandemic and the ways in which these crises and as well as kind of opportunities and new ways of thinking about old problems are kind of allowing us to expand our gaze. So I want to kind of come at this conversation with that in mind. I have some slides. I'm going to probably skip ahead on some of them because I'll run out of time. But I wanted to just share my screen. Hopefully you can see that. Yes? Great. Okay. So this is the case that Rachel mentioned that has really formed a lot of my work. I ground much of my work in my conversations with Jessica Lenahan, formerly Gonzalez, and I like to always honor her because I feel like she is alongside me as I'm speaking. She is my client, but more importantly, really kind of a thought partner and collaborator, and has become a leading women's rights activist after a horrific tragedy that you can look up and we can talk more about, but essentially involves the abject failure of the police to respond to her calls for help to enforce a restraining order in Colorado 20 years ago, and a terrible tragedy which ensued when her husband, who kidnapped the kids in violation of a restraining order, showed up at the police station 10 hours after her calls for help and opened fire. The police shot and killed him and found the bodies of the girls dead inside his truck. And the question that went up to the Supreme Court in Jessica's case was whether the police had a constitutional obligation to enforce her restraining order under the Due Process Clause, and the Supreme Court said no. And so we took the case to the international human rights arena and asked, does the United States have an obligation to respect victims' rights, to improve its enforcement of restraining orders, to fundamentally kind of honor victims' dignity, and has the United States committed a human rights violation through the practices of the Castle Rock, Colorado Police Department, as well as the decision of the Supreme Court? And this International Human Rights Commission answered affirmatively, right? And they directed the United States through a series of recommendations to come up with some policy solutions as well as individual reparations for Jessica. What I want to kind of go through is kind of how that has played out. There is no concrete enforcement mechanism, and I can get more into that in the Q&A. But what there is a lot of political and moral pressure that comes with international human rights decisions if you can kind of leverage them in the right ways. And so I want to kind of tell a story of how a group of advocates leveraged those principles. Lee mentioned this survey, so I won't go into it. The bottom line of this survey from the National Domestic Violence Hotline, as she mentioned, is that women, only 50% of women who call the hotline in the survey actually interacted with the police, but the vast majority of both those who did and those who didn't would not want to call the police again, right? So bad customer service ratings. This is not a system that is working for many women, as Lee underscored. And so, as the other speakers have talked about, we have a national landscape where many victims are reluctant to turn to law enforcement. They encounter significant barriers when they do seek law enforcement assistance. And yet at the same time, many police departments say the majority of their calls to 911 are for domestic violence, and that these are amongst the most dangerous assignments for responding officers. And then kind of one other contextual point is we have this conversation about bias in policing that of course has captivated our national attention, but oftentimes leaves gender out, right? And is not an intersectional bias conversation for the most part, particularly in kind of mainstream spaces. And so alongside Rosie Hidalgo and others, Rosie is now actually the White House Senior Gender-Based Violence Advisor, kind of a new version of my old position. She and I have developed kind of this idea of alternative pathways to safety, no wrong door, that we need to think about kind of improving alternative pathways to safety, many of which Lee really powerfully underscored, looking away from the criminal legal system in terms of thinking about safety and justice for survivors. But I want to, and so those non-law enforcement responses are critically important. Many people on this call, I suspect, have great expertise in that. And my dear colleague, Kim Leary, who will speak after me, is going to speak about kind of her perspective as a public health practitioner. But I also want to speak about, and I deeply believe that we cannot and should not kind of turn away immediately from the criminal legal or law enforcement system. I think we have to continue to work at improving it, troubled as that may be, complex as that may be, and fraught as the history of those efforts have been. And so without kind of turning a blind eye to the complexities of and frankly many of the failures to improve that system in the past, I think we need to continue to think about kind of how we could do that. And particularly in the context of the most marginalized populations of survivors, I think we need to be thinking about kind of how unbiased and trauma-informed law enforcement responses can be improved, created, et cetera. And so I just want to talk about one particular mechanism that I have some faith in as a means towards some of that improvement. This is guidance from the Department of Justice, which followed investigations by the Civil Rights Division from 2011 to 2017. For the first time in its pattern and practice civil rights investigations, the Department of Justice took on a gender lens. They looked at all the typical things they look at in terms of bias in policing, but for the first time, they didn't just look at quote unquote the gendered male areas, but also looking at areas that are typically affecting women and LGBT individuals, such as law enforcement responses to domestic violence and sexual assault. And so these 6 different places were subject to DOJ pattern and practice investigations, and these resulted in consent decrees, which means agreements between the Department of Justice and these municipalities. Following that, the DOJ developed this guidance. Guidance is not law, but it is guidance that basically underscores the DOJ's interpretation of the civil rights laws and its guidance to the 18,000 law enforcement agencies across the country about what how they should be policing and policing and responding to domestic violence and sexual assault. And so you see they came up with a set of 8 different principles. I won't go into them in detail here because I'm just about out of time, but they focus on kind of the bias piece, the trauma-informed piece, appropriate investigations, holding officers accountable. Lee has done some really important work that really underscores the vast prevalence of officer-perpetrated domestic violence and sexual assault. So I think I will leave. I have so many more things I could say, but I want to leave us with kind of this infographic that is a nice segue to Kim, because I've had a chance to work with Kim both in our White House days and then following our White House days when we got together and talked about what it would mean to take that DOJ guidance as it applies to law enforcement and think about its application in other systemic areas where bias is present, which is everywhere, and what it might mean to kind of move from practice to policy and translate that guidance into the women's into the mental health and public health space. So I'm going to leave with this slide. Happy to return to this. I know there's a lot on here, and turn it over to Kim.
Great, thank you. My pleasure to introduce our last speaker, Kimberlyn Leary, who is an associate professor of psychology at the Harvard Medical School and an associate professor in the Department of Health Policy and Management at the Harvard T.H. Chan School of Public Health, where she directs the Enabling Change program. Dr. Leary is also the executive director of policy outreach and of the Center of Excellence in Women's Mental Health at McLean Hospital. So without further ado.
Well, hello, everybody, and thank you very much for the lovely invitation to be part of this conversation. I should also mention that I'm at the Urban Institute as a senior vice president right now, so just to get located in time and space. What I'd like to do is speak about mental health emergencies as a kind of adjacency to what we've been talking about thus far. And I do that for a couple of reasons. One, it's something that we've been thinking quite a bit about over the last period of time. And two, because there's almost a natural default that we hear when we begin to talk about intimate partner violence, domestic violence, when we talk about institutional bias, and that's a turn to the mental health as a place that can offer resources and healing. And while that's true, I think it's important that we also look at some of the challenges that take place in the handover, if you will, from one system to another, and in particular, the challenges of when policing and the mental health response come together. So that's what I'm going to talk about. And as I said, I think it's an adjacency to the conversation that we're having. So as we mentioned, it's a difficult time right now, even though there is light at the end of the tunnel. And according to the American Psychiatric Association, 62% of Americans feel more anxious now than they did before the pandemic. Drug overdose deaths in the US have increased, reaching 81,000 from May 2019 to May 2020, and that's a 12-month high. And when we look more granularly at who is experiencing what kind of pain, what we learn is that young people and teens and children are experiencing some of the worst forms of psychological distress, again, based on emerging research. And according to the CDC, over this last year, there was a 30% increase in 12 to 17-year-olds who were admitted to hospital emergency departments for mental health issues. Now, in some sense, those are the lucky ones because they were positioned at least to access care. Existing crisis response services, things like crisis helplines or mental health teams, hospital services, are limited in scope. And more often than not, those services across the continuum of care are not well integrated. Reductions in hospital beds and services mean that hospital admissions typically only occur in a mental health context for those who are in acute crisis. And even then, only for very short periods of time to kind of stabilize people is the language that's used. Now, this is where the policy comes in and unintended consequences, because this was actually the goal of mental health reform beginning in the 1970s. Which sought a shift from institutionalized care to care that could be community-based. But the unintended consequence is probably what you would imagine, is more people, more persons with mental illness in the community without the funding needed to support the systems that would allow providers to keep pace with the increased need. So without a comprehensive and integrated system of mental health care, it's not surprising to recognize that families have few options when a loved one's mental health challenges exceed the family's resources to care for them, or when they're frightened by their loved one's behavior. So an analysis of police calls in the Washington, D.C. area a few years ago indicated that the most common cause of police contact for those with mental illnesses was a call to 911 from a member of the family or a friend. Now, this is a trend that may be exacerbated in communities of color because mental health care is even less available in under-resourced communities. And in communities of color, it's even less likely that someone with a mental health issue, mental health condition would be properly diagnosed, or if diagnosed, that they would receive adequate care. So it becomes even more probable that police would be called, again, often by families, to respond when an individual is facing a mental health crisis. And as Carrie mentioned, this linking of the law enforcement and health and mental health side disproportionately affects the most vulnerable. We need only to think about the sexual assault, sexual abuse, sexual trauma to prison pipeline. Now, as you think about what I've just described and laid out in broad scope, this is essentially a platform for tragedy. In that study that I mentioned, the Washington Post reported that of 124 cases of officer shootings, 27% of all officer shootings involved a mental health crisis. And in a third of those cases, the officers were explicitly called upon to help the person get medical treatment, but the officer shot them instead. So we have to ask, how does this happen? Well, when police respond to a person in a mental health crisis, they are trained to respond as though it were a typical criminal emergency situation, typically with a show of force and authority. And further, they tend to treat a person in a mental health crisis as though they had the same intentionality as someone who is not in a mental health crisis. So a person in a mental health crisis is apt to say very disturbing things, and they may not be able to follow an officer's direction or commands, as they so often describe them, even if they wanted to. And a person in crisis may well be holding a weapon, a baseball bat, or even a knife, for their own protection, not with any expectation of hurting someone else. But this is the kind of nuance that disappears when police are called in to protect or enforce public safety, and also as mental health responders. And these two roles are essentially in conflict, typically resulting in an escalation of the crisis. And that escalation can result in increasing the risk of injury or death for members of the public, for the police, but most often for the person in the mental health crisis, himself or herself. Now, everyone suffers with this kind of a platform. The people who call for help and their loved one is shot by a police officer, they suffer. Clearly, the person who's been shot or killed suffers. And many officers report that the experience can be traumatic as well when they discover the circumstances that have resulted in being called and that the family's hope was for care. So how can we do better? The goal, of course, would be to improve the response to persons with mental illness. And a number of US cities and cities around the world have important initiatives. In New Haven, Connecticut, for example, and in other cities, mobile teams of mental health professionals are dispatched to respond to a mental health crisis rather than law enforcement. And that has shown some positive benefit. Mental Health First is a program in Sacramento, California that uses a hotline, and from that hotline dispatches a team of mental health professionals, volunteering their time to respond to mental health related calls. Some of you have probably heard of Cahoots, or Crisis Assistance Helping Out on the Street, another mobile crisis intervention team that's been integrated into the public health safety system in Eugene and Springfield, Oregon. And there are a number of initiatives that are trying to divert, when a call comes in to dispatch, to try to divert non-emergency calls to these kind of mobile crisis units. Now, there are a couple things that I'd like to say about this, about what has been found to contribute to the success of these programs. The first is that when the people involved, the responders, whether they're police officers or mental health providers or others, when they have specialized crisis intervention skills, that helps a lot. The second issue that's really important is training that's directed towards dispatchers, because the dispatchers are actually playing a critical informational role in sending people in one direction or the other. The dispatchers are not, in a sense, neutral. They are really driving the whole show. And I think that that's a place where a lot of innovation could be made. And finally, there has to be an evaluation protocol so that we can see what works for whom and when. Now, in closing, let me just say that a challenge like this of behavioral health emergencies in under-resourced communities, and what do you do when families are scared, is a species of what we might call an adaptive challenge, where the problem looks different to different people based on their values, history, and loyalties. And when people come together and try to solve these problems, sometimes it looks like they're not making much progress. But it's not that they're really resisting change, some leadership scholars would say. Instead, they're rejecting loss. Each of these stakeholder groups has a set of expertise. Police officers are wanting to deploy their expertise, mental health people theirs, and it's how that collaboration can be designed to be most effective. So when we think about the stages for success, we think it requires 3 dimensions. The first is data-driven approaches that create a common platform for decision-making and improving the data, including that coming into dispatchers. Also, critical is community-engaged methods and community participation, so that systems of care understand what it takes, and as a final step to someone picking up the phone and calling the police because they can't cope any longer with the situation at hand. And the third dimension of this is what we would call change management at scale. So in order to change the kind of culture of collaboration, we have to look across the whole system, and we have to identify where we are now, where we want to go, and look stepwise at the vision and at the first steps and middle level steps that will get us there. Thank you.
Wonderful, thank you. So we have about actually until 2:55. We have a little bit more time, and so we can take some questions from the audience. I know I have a million questions I could ask, but for so that we can hear from some of the participants, let me open it up for questions from the attendees. Well, it's very tempting for me to ask the first question, so I'm going to. So I loved each presentation, and I thought there's a fantastic thread throughout and thinking through from where does change come. And so I'm curious in all of your thoughts about the kind of next wave of reform in this area, and really where is it coming from? So we have a story around there being rethinking incarceration, rethinking law enforcement, thinking about the role of public health interventions. But I'm just curious about your thoughts about how federal, state, communities are agitating for change, and what does this new generation, for instance, of intimate partner violence reform, what does that look like?
So I'll jump in if nobody else is going to. I think one of the things that's really interesting that's currently happening is that so much change is coming from the community level, and the demand for change is coming from the community level. And it seems to be starting to shift conversations that are happening among the national policymakers who've been responsible for setting this policy for such a long time. And so, the Black Lives Matter movement has had a tremendous impact on the conversations we're having about how intimate partner violence should be dealt with in the future. And the defund the police movement is having a tremendous impact on those same conversations, so much so that, in fact, yesterday, the National Resource Center on Domestic Violence put out a statement saying, We need to rethink our commitment to criminalization as the primary response to intimate partner violence in the United States, that we recognize that we have been complicit in forwarding or advocating for a system that has been deeply harmful to many communities in this country. And so I am actually really excited right now about the potential for having a very different conversation. It's a conversation that I've called, how do we get to a non-carceral VAWA? How do we take the signature piece of federal legislation and move it from being a huge source of support for law enforcement to something that does work around prevention and work around economic support and work around public health and community-based responses? And I think that those conversations are happening because of what's happening at the grassroots level. When you see organizations like Embrace, which is a primarily white organization in rural Wisconsin, putting out a Black Lives Matter sign and having, a groundswell of support from around the country after law enforcement basically cut off a significant portion of their funding, that things are changing in this conversation, and that's what has me really excited.
I would just jump off of that and agree with everything Lee said, and say that in Miami, I teach at University of Miami Law School, and we have been involved in a survey and documentation project with advocates who serve underserved populations of survivors in the Miami metro area. And we've been conducting interviews and focus groups and surveys of advocates, very broadly defined, including kind of people who in their professional capacity or in their community organizing capacity come into contact with survivors and are steering or providing services in some way, as well as we've interacted with survivors. And what we're finding is like the conversation about law enforcement is actually largely a non-issue for many of them. They want to talk about the lack of public transportation in Miami, the food shortages that they're experiencing, housing, health issues. And so all the things that like in human rights talk, we would call social and economic rights, right? Things outside of the criminal legal system are the things that are really preoccupying a lot of our community stakeholders and survivors. But then you shift into more formalized and historicized kind of groups that focus on domestic violence and sexual assault at the community level, such as, for example, in Miami, the Domestic Violence and Sexual Assault Coalition of Miami-Dade County. And that coalition is composed largely of people in the criminal legal system. And so the conversation that they are having and the perspectives that are coming in through that channel are like a world apart from those that we've been collecting through these other channels. And I see the conversations like sometimes they're naturally coinciding, but more often than not, they are separate spheres. So I think part of our role as advocates is to try to create those bridges and serve to the extent possible, kind of to bring those perspectives to those more formalized traditional DVSA spaces, as well as to local policymakers. And so in Miami, we're excited. We have our first woman mayor ever. She's a social justice lawyer. She's been a very important community-based actor. And so we're really hoping that we can use the COVID kind of DV COVID research that we've been doing to both kind of change the structure of the DV infrastructure in Miami, as well as kind of larger legislative initiatives and policy priorities at the county level.
Can I just add one thing to the general question? And I know there's a discussion in the chats about practical strategies, but as is my penchant to do, I'm going to talk about something a little bit unpractical. But I think what's really interesting is sort of policing, the idea that the arrest policies and the policing and the sort of arrest them all and don't even think about it is just an internal policing thing. It's not, right? Like it is, there's many, many factors. And so like one of the things I think a lot of us agree with is just getting rid of mandatory arrest policies, right? Like putting the discretion back in there and also alternatives. But, you know, one of the factors is if you put the discretion back in there, you know, and then, you know, police fail to arrest and, you know, a really bad act of violence happens, or a very rare, but, you know, a homicide happen, which is not predictable by arrest policies or whatever, but that is what is going to get covered by the press. And in turn, the police departments are going to feel enormous pressure because you have this older model, an older way of thinking that, oh, when there's a harm, it's a failure of the police to be sort of pro-arrest enough. So the police are also in that mindset, which I think through all of our work, it's just like empirically, it's wrong. That's not kind of the root causes of the harms. You know, so I think there has to be more than just kind of internal police, but there has to be a broader public conversation, which gets to the Black Lives Matter issue. And, you know, one of the things that was really interesting at the beginning of the pandemic, there was very spectacularized coverage of the epidemic of domestic violence in terms that one would normally expect to go totally towards more law enforcement. Law enforcement should be going into these homes, we should have more. And it was more tempered than I would have thought, with, you know, ideas of alternatives, services, getting the pandemic under control, right? So people could leave their homes. And I do think that is a function of the Black Lives Matter. So I just wanted to underscore the feedback effect between community ideas, press, and policy.
And I'll put in a last word for explicitly thinking about what we know goes into managing change in organizations and communities. Ideas alone do not drive change, but engaging people from what matters most to them and interesting them in what matters most to you usually allows people to find the right synergy.
So we because you're so fascinating, we keep getting more time, but we do have a hard stop at 3. And I think there's time for just the question posed in the chat. In other sessions in this conference, there has been sustained attention to systematically reducing the role of criminal law and police in dealing with social behavior that has unnecessarily been defined as criminal. So I think relating to some of the comments just made, how, if at all, does this thinking apply with IPV, which in key respects easily fits the definition of crime?
I guess I'll jump in again. You know, as the person who wrote the book called Decriminalizing Domestic Violence, I mean, there are a couple of different ways that one could go about this. Now, I think it's highly unlikely that we're ever going to decriminalize assault, for example, which is the basis of the probably most prosecutions for intimate partner violence. I think for us, the work more has to be on addressing the correlates of intimate partner violence. Male under and unemployment, the single greatest correlate for intimate partner violence. Looking at trauma and the impact of adverse childhood experiences, looking at guns in our community, looking at economic distress and economic dysfunction and community instability, all of which highly correlate with the perpetration of intimate partner violence. I don't think any of us thinks that we're going to end intimate partner violence, that we are human beings and we are violent people, and kind of that's kind of what that is. But all of these correlates that we can get at the front end are going to significantly decrease the problem at the back end. And then when you have things that kind of meet the definition of crime, then hopefully you have a better way to address them, in my opinion, than caging people, but that you are able to address those crimes in ways that actually get at the things that are causing those crimes to happen in the first instance. And so it's a combination of things. It's a much harder question than, say, decriminalizing drugs. We could do that tomorrow and we could deal with drugs that way. Intimate partner violence is a much more complicated policy question, but I think some of the same ideas guide us. And for me, the real place to start is, how do we get at the things that we know are highly correlated with intimate partner violence? And it's not just power and control, which has been the feminist narrative for time immemorial. It's all of these other things that we need to be looking at.
Last word?
And let me just add, like a shameless plug for my book too. Like when you look at the 60s and the burgeoning sort of and 70s and burgeoning awareness, it was a really a social science approach to domestic violence, looking at the stressors, both external and internal to the family, and that was actually the original idea, and it just became sort of the prototypical crime. And I'll add that everyday assaults are decriminalized, right? Like not, like first degree injurious, but that was a model too, that, when two people are in a fight on the street, you can also mediate that. And I think we have to understand that those were all roads not taken. Those were like criminal law was the alternative. And now we're looking for alternatives to criminal law.
Well, with that, we need to end. I just want to thank the panelists, thank the attendees, but learned so much. Thank you all.